But he's responding.
In accordance with this constitution.
ये कोई रिस्पॉन्ड करना चाहेगा? ये फैक्चुअल क्वेरी है. Don't argue the case. Mr. Makhdoom Ali Khan says that there was no commission constituted by the political parties. Is this factually correct?
No, incorrect.
So where is the document showing? No, where is the document to show us the commission's constitution?
So that's why I was saying for a while, because they are now presenting it without proper notice to us. But we have satisfied the High Court. And one more thing which I want to say.
No, Khan Sahab, we will certainly hear you, don't worry. Because when a factual statement is made by counsel, the way I like to proceed is, I want to narrow the controversy as much as possible. If that factually is correct, I will take it as correct. So I always call upon the other side sometimes, is this factually correct? They say yes, no. So then we will say, then the question will arise, where is the proof of it? So if either you accept his statement or you don't accept his statement, you can certainly refer to any document or something you filed. We certainly will consider that.
Sir, but one thing which I wanted to request, prior to coming on the facts of the case, the question of maintainability, may be allowed to make my submissions on maintainability, locus standi of election.
No, but if we talk about maintainability, then you'll have to argue first.
Yes. On the question of maintainability.
Yeah, but then because you said you wanted some time to prepare yourself, so we are just getting the facts because you may not have time enough. So we're just trying to save time. So we're just going through the case to understand it. And yes, you can say I reserve my right to argue on maintainability. We certainly will hear you, but we're just trying to cover some ground because probably you're not ready yet. Fine, that's fair enough, and we will give you time.
But a preliminary objection can be heard prior to.
But then, provided you are ready to argue it, if you're ready to argue it, we'll hear you.
On the preliminary objection that they have no locus standi to.
Fine. Do you want to argue it now? We'll hear you.
Yes, that's
ready with it.
Argue now because
you never said so. That's why you said you will argue tomorrow. So that's why we said okay.
That's about the facts and other things. But right now, the relevant thing is whether they have to show how do they have the locus standi to file this petition. Election Commission is a quasi-judicial body.
Correct.
Two judgments of this honorable.
No, let me just correct you here. Election Commission is not just a quasi-judicial body, it's a constitutional body.
Constitutional
It has,
body.
from my understanding,
Right.
it has two functions.
Right, sir.
One, regulating the affairs of political parties, and which is the ongoing exercise, and the other is the free and fair elections. So probably we are at the moment in the first thing, that regulating the affairs of the political party.
Right.
I would imagine, unless I'm wrong.
I'm trying to submit here is that it is a body which has a power to make quasi-judicial decisions. It's a quasi-judicial body when the matter of dispute between.
Their decisions are orders. They can be
This
absolutely.
Honorable Court has very recently held in 2 cases that such bodies have no locus standi to file the petition and come before the Supreme Court in defense of their own orders. So kindly consider those 2 judgments. In the light of those judgments, they have no locus standi to be here.
देखिए, ये तो फिर भी कॉन्स्टिट्यूशनल बॉडी है. एक सेकेंड. Even the collector appeals comes to the High Court, comes to the Supreme Court, when even though it's his own order, he is arguing his own order, effectively speaking. So ये तो constitutional body है. तो just देखिए, then there will be another issue. Then another question of maintainability will arise. If you are questioning their maintainability, then the question of your maintainability will arise. How can you approach a High Court? फिर वो क्वेश्चन आ जाएगा.
Naturally, any adverse order I have right to challenge.
No. Which forum? The Supreme Court. अभी पहला हमने केस सुना ना, क्या नाम है, APML. वो कानून में लिखा है टू कम टू द सुप्रीम कोर्ट.
डायरेक्ट अपील है वो. डायरेक्ट अपील है.
तो फिर वो क्वेश्चन ऑफ मेंटेनेबिलिटी विल आल्सो कट यू.
No, sir. The thing is, as far as their locus standi is concerned, there are 2 judgments of statutory bodies.
Locus standi, simple सी बात है ना. Locus standi is a different thing from capacity. Their local standard, from what I can understand, is they have passed an order. There's right or wrong is a different thing. We don't go there. And they say if we have to ensure our orders are abided by, unless set aside by a law of a competent forum. So all they are doing is ensuring whether, even if it's an illegal order, let's not get bogged down in that debate. If they just give up, then the orders will be rendered meaningless.
Isn't that affected party, which brought the matter before the election commission, has the local standard to file, but not the election commission?
Affected party can inform the election commission for whatever reason. The election commission may act on its own. Election commission may act on the information of a person. But now that they've passed an order, they're not entitled to defend their own order and surrender.
That's what I'm submitting. Just like the
on
example.
what basis?
Kindly see the case of a district judge. He passes an order. That order is challenged before the High Court. High Court sets that aside. Can the district judge come before the Supreme Court that in defense of his own order? No, it's a judicial body. Judicial body cannot.
There is a slight difference. Not a slight difference, a major constitutional difference would arise. The district judge falls under the hierarchy of courts to be supervised and controlled by the High Court under Article, I don't know, what is it, Makhdoom?
Whatever it is. I'm just giving an example.
नहीं, वो example लगेगा नहीं. Now this is a separate body. You cannot apply that argument. It's a separate body. I've given you the example of Collector of Customs. Every day they are filing before us. Collector of Customs appeals. His own order is come and it's been turned upside down by the High Court. So he comes before us. We hear him. Nobody's ever raised an objection that they can't be heard.
There are two cases recently in which this Honorable Court has held.
बताएं कौन से? Which are those two cases?
Yes, those two cases. The recent one is 2023.
PLD?
PLD 2023, Supreme Court, page. Page 516.
And the other one?
And the other judgment, where the ombudsman has.
Other judgment, yes.
The other judgment is PLD 2020. 2020.
Supreme Court.
Supreme Court 586.
What was the facts of the first case?
They have held.
The first case, बताइए, let's go to 516. What is the ratio in that case?
Yes, they held the order which was passed by Commissioner and was challenged subsequently before the High Court, before the Appellate Forum and High Court.
Which commissioner?
That the commissioner cannot come.
The commissioner, election commission.
Yes, not the election commission. In that case, it was competition commission.
Gee.
But there is a clear judgment.
Okay. So how is it? No, let's finish with one judgment at a time. How is this judgment applicable to a constitutional body?
Sir, kindly see para 23, page 535. Why I'm putting this before this honorable court?
Please.
The whole exercise may
Let's read
be
it.
unnecessary.
No, let's read it. To be honest, I've not read it, so let's read it. You may well be right.
Page 23.
Gee.
It may also be petitioner to mention here that KNN's food which may have been aggrieved of the decision of the tribunal on the point of non-applicability, the provisions of section 10(2)(a) of the Act has been impugned the decision of the tribunal by preferring an appeal to this court, and it is the commission that has challenged the decision of the tribunal on that point by filing the appeal. In this regard, we may observe, though the role of the commission under the Act is primarily of a regulatory body, it is a quasi-judicial, as well as some provision, as well under the same provisions of the Act. The provisions of clauses A and D of section 10(2)